My Hello, everyone. We will just wait a few minutes for all participants to join us.
Oh, thank you so much.
So yeah, I believe we can start. Hello, everyone. I'm Ivana, and on behalf of Science Technology Park Belgrade, I would like to welcome you all. Science Technology Park Belgrade is organizing this webinar with the support of the Swiss government under the project Technopark Srbija 2, boosting export through technoparks and raising starts program, together with the Swiss Federal Institute of Intellectual Property. First of all, I would like to thank our speakers for being here with us today, Ms. Zhao and Mr. Moetley. It's our pleasure to have you with us today, and thank you for your willingness and time to share your expertise on this very important topic when it comes to intellectual property, especially for those who want to expand their businesses on US and China market. Thank you. Thank you all participants for joining us. We're glad that we can share knowledge and inputs with you on how to get ready and how to protect your innovative business on your global path. I would also like to thank David from the Swiss Federal Institute of Intellectual Property, who will moderate this event. David, nice to see you and thank you for your support. Just one note before we start that this webinar will be recorded. So yeah, I believe that now we can start and I wish us all a productive event. David, please, the floor is yours.
Thank you. Good morning, everyone. My name is David. As told, I'm from the Swiss Federal Institute of Intellectual Property, and I'm really glad to have two experts here who will give us a quick overview over the trademark system in China and the US. What should you consider when filing a trademark in China or in the US? What are the hurdles? What are the traps of the application procedures? Do you have to choose other words for a trademark in China because they have a different meaning there? I'm really sure that this and more possibly asked questions will be covered in the next 2 hours. There will be 3 sections. First, we will talk about trademarks in China. Secondly, then trademarks in the US. And for the last 40 minutes, it's on you to ask questions and to discuss with our experts. You are really free to write questions also in the chat. At the end, we will cover them, hopefully all. And that said, I will give now Mrs. Ling Zhao the floor. She's a senior trademark attorney for over 20 years experience in trademark prosecution, administrative protection of trademark rights, trademark litigation, and trademark strategy. She was awarded as Trademark Attorney of the Year by the China Trademark Association in 2019. So, Mrs. Zhao, the floor is yours.
Thank you, David. So, hello everyone. Good morning. So I'm very glad and honored to speak today about trademark registration and protection in China. So I'm going to share my screen so that you can see my presentation. Okay. Is that okay?
Yes, we can see it.
Okay. So why should we register trademarks in China? how to register our trademarks, and in which classes do we register our trademark? And should we also register a Chinese character trademark? What else do we need to learn about the trademark law in China before entering the markets? I hope you can obtain the answers to all the questions after this webinar. Before that, I would like to briefly introduce about my law firm. We are one of the largest IP law firm in China, with a history date back to 1957, the first trademark agency in China, helping foreign companies and individuals to obtain trademark registration and protection in China. We have been ranked as the leading or top IP law firm by most influential and professional magazines, like MIP, Chambers, Legal 500, and Asia IP for our patent and trademark prosecution services. We have served applicants from all over the world and in all industries, including startup companies as well as large multinational companies. We have over 600 people, among them 300 professionals. So thank you. So the first part, I'm going to talk about the basic rules and procedures about trademark registration in China. First, let's have a brief look at the current status of the trademark registration and protection in China. So since the year 2016, the number of national applications in China has increased rapidly. You can see it here. So to the year 2020, the total number of national trademark filings have reached over 9 million in China. So Class 35, Class 30, and Class 25 are three popular classes in the application favored by the Chinese applicants. So Class 35, you know, that is for services such as marketing service, import-export agency, sales promotion for others. And Class 30 is for food, and Class 25 is for clothing. So even though So despite the increasing number of filings each year, our trademark office has done a very efficient work. So the average term of the trademark examination has been shortened to 4 months now. By the end of the year 2020-21, the total number of registered trademarks in China has reached over 37 million. So, all right, now with the background information, now let's go through the 5 questions here. So why should we register trademarks in China? How should we register our trademark? And in which classes? And do we need to register Chinese character marks, or what else do we need to learn before we enter the markets? First and foremost, only a trademark registered in China can obtain protection in China. Although there are several rare exceptions, the biggest benefits, of course, for registering trademark is to get protection in China. Except for cigarettes, which need to be used with a registered trademark, the China trademark law actually allows we to use unregistered trademark in the markets. However, there are the risks if we use an unregistered trademark. Your trademark could be hijacked by a competitor, a Baptist trademark applicants, or even your distributor in China. Trademark squatters may even record the hijacked trademark with the Chinese customs, and then the imports and export of the goods will be blocked. There are also the risk of infringement upon a third party's legal rights and cause disputes if we use an unregistered trademark. And also there is potential risk to violate administrative regulations if the trademark are improperly used. So what types of trademark can we register? So registered trademarks are any size capable of distinguishing the source of the goods or services, including words, devices, letters of an alphabet, numerals, 3-dimensional marks, combination colors and sounds, and as well as combination of all these signs. So except for trademarks, authorized trademark use on goods and service, we have also collective trademark certification marks, and we also protect geographic identifications. Here, this one is a three-dimensional mark. This mark is a color combination, and this is some mark. So requirements and procedures. So foreign applicant need to appoint a Chinese trademark agency as their representative of trademark applications before the China's National Intellectual Property Administration, CNIPA. But if it's an international registration with destination in China, you don't need to appoint a trademark agent, a Chinese agent at the filing stage. But if there is an office action or official refusal issued by the China Trademark Office, you need to appoint a local agent to represent you to file a response or review before the CNIPA. So for filing national application, here is the procedure. We file online, and then we for formality examination, substantive examination takes about 4 months. If everything is fine, then the mark is published for 3 months. If no opposition is raised against the application, then it matures into registration. So for now, we only have an electronic certificate issued by the CNIPA since this year. So there's no paper certificates any longer. In case the application got refused or partially refused due to others' prior rights or other reasons, then we can file a review with the review board, also under the CNIPA. And the review procedure usually takes about 7 months. If after 7 months review and our mark gets registered, gets approved, then it will be published for 3 months opposition period and then mature into registration. In case our mark was refused again by the review board, then we can further appeal to Beijing IP courts for the first instance trial, and then Beijing High Court for the second instance trial. You may wonder, what are the pros and cons of filing national applications instead of an international registration through material system? You can see the benefits of filing national applications in the following 4 aspects. So first, examination period for national applications 4 months is very fast. For international registrations, it will be 12 months if it's material agreements route and 18 months. The CNIPA will strictly require that the descriptions of goods and services to be acceptable under our current classification in China. Otherwise, an office action will be issued. But that's for national application. But for international registrations, the CNIPA will not issue an office action in case any the goods are not accepted. However, if the goods and services do not belong to the file class, the China CNIPA will issue directly an office refusal. We have to file review. And for review time limits, for national application, is if we file in paper, it's 15 days. But if we file online electronic filing, the term is 30 days, like the international registration. So for registration certificates, the CNIPA will only issue electronic certificate as mentioned. But for international registrations, the CNIPA will not issue a certificate automatically after the mark is granted protection in in China. We have to apply for a certified copy of the registration with CNIPA when necessary, which costs about $100 US. So when you decide to go file a national trademark application in China, we need the following documents. Like a power attorney, a certificate, a company registration showing the good standing legal status of the applicant, or if the applicant is an individual, we need a copy of his passport or other ID documents like a driver license. And we need to give us the sample of the trademark and list of the goods and services. And we need to give me the name and the address of the applicant in English, but no notarization or legalization is not required of any of the documents. We only require a copy of the power to side power as well as a copy of the certificates of the company registration. Okay, there are 3 very important issues I would like to draw your attention to for filing national applications. First to file and subclass system and substantive examination. So what is first to file? First, China trademark law adopts the first to file rule for obtaining trademark rights, which means the first applicant to file an application for registration of the trademark will preempt other later application for the same or similar trademark in respect of the identical or similar goods. If 2 or more applications are filed for the same mark or similar mark in respect of the same or similar goods on the same day, the trademark used first should prevail. But if there's no prior use, the seniority will be decided by lottery. So do we need to prove use of the mark in China or elsewhere when filing an application? The answer is no. So about the first to file rule, we would like to talk about the New Balance case. The New Balance is a famous sportswear brand. Back in the year 2016, New Balance was sued by an owner of Chinese character mark Xin Bailun for infringement. The reason New Balance used to use the same Chinese character mark in China as a Chinese equivalent for the English mark New Balance. But it happened that a Chinese individual had registered the Chinese mark in class 25, covering all the goods used by New Balance. So the use of the same mark by New Balance constitutes infringement as decided by the courts. In the first instance, New Balance was ordered to pay damages amounted to 98 million RMB, which is amount to 30.8 million euros. The final amount was decided as 5 million RMB by the second instance court, but still that's a lot. So if New Balance had registered Chinese character mark before using it in the Chinese market, it should have avoided conflict. So the second issue is about the subclass system. So China adopts this classification, which is composed of 45 classes of goods and service. But China also operates a special subclass system in which the subclasses in each class work independently. The subclasses are determined based on the similarity of goods in terms of functions, uses, raw materials, sales channels, consumers, etc., and also similarity of services in terms of purpose, contents, and the consumers, etc. So what's the significance of the subclass system? It's very important to define the scope of protection of the trademark and also to determine the similarity of the goods and services when encountering a prior similar mark. Let's take example here. So for example, there are 2 ABC trademarks by different owners. One is registered for clothing and footwear, and the other is registered for headgear, both in class 25, but the 2 marks can coexist with each other without conflict. For according to the official criteria, the goods of the 2 marks are not similar ones because they belong to different subclasses. So take class 25, for example, it has 13 subclasses. So generally speaking, goods in different subclasses are not similar goods. So you can see that clothing, footwear, headgear belong to different subclass. And then we have the accessories of clothing like socks, gloves, neckties, belts, wedding dresses. They belong to different subclasses. They are not similar to each other and they are not similar to clothing. So, so if we register mark for the goods clothing only, our mark will be only protected in the subclass 1. And also similar goods in this class, but not on footwear and headgear. So we usually suggest our client to register in all the subclasses in the same, in order to obtain protection for the whole class. Also, another example, in order to get sufficient protection for your trademark, it's not enough to cover all the subclasses in one class, maybe, but also in relevant classes. For example, if you are a pharmaceutical company, you will wonder in what classes to register mark in order to get sufficient protection. We know that pharmaceutical for human use belong to class 5, but medical devices and products belong to class 10, and retail and wholesale services for pharmaceutical preparations belong to class 35. And medical research belongs to class 42, and we have a medical clinic service for in class 44. So, so we will suggest to designate your products to secure your trademark rights for safe use. And at the same time, maybe you should designate relevant goods and services to secure sufficient protection scope. And also, according to current practice of the China trademark law, the examiners will require the applicant to designate a standard descriptions of goods and services. If not, we may expect an office action requiring amendments of goods and the wordings of the goods. Usually, we'll receive the office action only once. If we refuse fail to amend the wordings according to the requirements of the examiners, then the application will likely be rejected. So to avoid an office action, we would suggest we use standard descriptions of goods and services for filing new applications. And also, we know that the list of standard goods and services are also in the process of evolution itself, along with the technology developments. A lot of new products and services are emerging every day. The evolution of the list of the standard goods and services of the trademark office is slower than the actual technology development. So edge-cutting goods and services may likely encounter office action, such as the metaverse-related goods and services, which is very popular recently. But the solution is to file for the closely relevant goods and services. For example, retail and wholesale services other than pharmaceutical products are not acceptable in China. We usually propose for a client to register for similar services in class 35, like a display of goods on communication media for retail purpose, sales promotion for others, providing online markets for buyers and sellers of goods and services, and marketing services, etc. For metaverse business, we can designate virtual and blockchain related goods and services like design, development of virtual software, user authentication services using blockchain technology, etc. in classes 9, class 41, and class 42. So the examination of trademark application at the trademark office usually include two stages. One is formality examination and the other substantive examination. So formality examination, we just had talked about, it focuses on proper filing documents, Chinese translation of the name and address the applicants, and clear trademark samples, and acceptable wordings of goods and services. After all this have been accepted by the CNIPA, then we move to the second stage, substantive examination. So the registrability of the trademark will be examined at this stage, including checking if there's any prior similar marks, identity marks in respect of the same or similar goods or services, and if the mark per se is sufficiently distinctive, and if the mark contains any words or elements that are not allowed to be used as trademark according to the trademark law. In short, there are two kinds of refusal grounds, namely relative grounds and absolute grounds. Conflict of prior rights are relative grounds of refusal, such as the examples in this slide. So the two marks are considered similar marks, and the later mark was refused. Then we file review with the review board to argue against similarity. In the meantime, we approached the owner of the citing mark and negotiated for the letter of consent. Luckily, the letter of consent issued by the owner of the citing mark has been accepted by the review board, and then the application is finally registered. But in the next slide, we see here, the two marks are highly similar. The two, as they composed of exact the same letters, although in different styles. Even though we submitted a letter of consent from the owner of the citing mark, still the application is refused because the examiner considered there's still the likelihood of confusion to the consumers. So the purpose of refusing similar application is to prevent likelihood confusion in the markets. A letter of consent can be helpful to convince the examiners that two marks can coexist without any likelihood confusion in some cases. But if the two marks are identical or highly similar, a letter of consent might not be sufficient. And according to the recent trend of the CNIPA as well as the court decisions recently, the examiners and the judges are getting stricter on acceptance of letter consent. And this is an example of refusal for lack of distinctiveness. Here we can see there's a very beautiful and famous Zhao three-dimensional trademark. This mark was initially refused by the CNIPA. Then the applicants appealed to the courts for first instance, second instance, and finally for retrial at the Supreme People's Court. Luckily, finally, the Supreme People's Court supported the claim of the applicants and give a favorable decision. And the Supreme People's Court ordered the review board to re-examine the trademark as three-dimensional mark. In the meantime, the CSPA comments in the decision that the review board should take the factors into consideration, including the long-term use of the mark in the Chinese market, its reputation, etc., to prove that it has acquired sufficient distinctness by long-term use in this market. Also, there is a special situation in this case because the Zhao three-dimensional mark has actually been registered before in the national application. So for this international registration, we should keep the consistency in examination criteria. So according to Article 10 of China Trademark Law, the following signs are not allowed to be used as trademarks. Any signs identical similar to name and national flag and military flag of foreign country, except with the consent of the government of that country, or signs identical similar to the name, flag, or of intergovernmental international organization, except we obtain the consent of the organization, and also, or if the sign is not easy to mislead the public. And also any signs identical similar to the Red Cross, Red Crescent, not allowed to be used as trademark. Any signs that has ethnic discrimination should not be allowed to be used as trademark. And trademark considered deceptive, which easy to cause the public to understand the quality and other characteristics of the products or the place of origin should not be allowed to be used as trademark. And also signs harmful to morality or customs or have negative social influence also are not allowed to be used as trademark. And foreign geographic names known to the public are not allowed to be used as trademark. So here, for example, this mark contains the state name Mexico, and so it's was refused. But there is exception. In case we can obtain a written consent authorization letter from the government of Mexico, the refusal can be waived. And the second mark contains the famous geographic name of in Japan, Tokyo, and this mark is also refused. In this slide, the 4 marks were all refused for being considered deceptive. But for different reasons. For this mark, it's considered deceptive due to the word group because it's not the same as the name of the applicant, which is Enterprise Hong Kong Limited. So for this mark, it was considered deceptive because it contains a descriptive sentence, which might not be true regarding to as to the functions of the goods. So it's considered deceptive. And this one was refused because of the word best, which is considered deceptive to the quality of the goods. And this mark contained the word milk, a product name, but well, the goods actually are cookies, so it is considered deceptive. And in this slide, the 4 marks were all refused for being harmful to the morality or having negative social influence. For this mark, it contains the word wet. The word refers to actually the temple in Thailand or Cambodia. And this mark contains the word God, which is not allowed because it will detrimental to morality or religion's belief. So, and the 3 marks below, they are all considered having negative social influence. So they are all rejected for registration, and I agree. So to avoid all of it, so in order to avoid being refused, we would suggest we avoid using words or devices liable to trigger official refusals, such as product names or deceptive words or devices. Words or devices related to religions, state names, or famous geographic names. Words identical with or similar to names or celebrities. Words or devices that contain negative meanings that may be considered detrimental to morality or with negative social influence. So till now, we have talked about the first 3 questions. Why should we register our trademark in China? And how to register our marks? In which classes should we register our trademarks? Now we have come to the most interesting parts about Chinese character trademark. We think the most famous brand active in Chinese markets have a corresponding Chinese mark. Because why? Because Chinese character marks are easier for Chinese people to pronounce and to remember. In the so we don't forget to register our trademark. Let's see some of the examples of the very good Chinese name for famous brands, like this one. Carlsberg has a registry in China. Not only its word mark in English, Carlsberg, but also Chinese mark, Jiashibo, and also to register stylized mark and also the bottle device here. And Lurpak for cheese, and he has also registered his word mark, device mark, also the mark, those elements in combination, and also its Chinese character mark. It's worth also, I would like to mention that we can register a word mark and a device mark in a combination, as combination mark like this one. We can also register them separately for the convenience of use. So now the interesting question is how to create a Chinese name for your brand. We have usually four methods. First one, transliteration according to sound or English mark. The Chinese mark has no fixed meaning as well, but a common word. But a common word is good to be used as trademark because it's highly distinctive. It's very unique, like the Chinese mark for Volvo. The 3 characters together has no meaning at all, and also the Chinese mark for Saab. The 2 characters together has no meaning at all. They are very, very good Chinese brand because they're highly distinctive. They're very unique. And also we have some Chinese mark seems irrelevant to the English mark in meaning or in sound, but they contain very good connotation, and they are also very good Chinese brands like the Chinese mark for Sprite. You know that the Chinese mark, the 2 characters are pronounced as 雪碧. It's not similar to Sprite in sound, but the first character 雪 means snow. The second character means green and red. And as a whole, 雪碧 has no fixed meaning, but because of the 2 characters, it delivers some kind of feelings of cool and green, which could remind us of the taste of Sprite and also the color of this bottle. And also Coca-Cola in Chinese. So it's transliteration according to sound, but with very good connotation in the Chinese character. So the first 2 Chinese character, 可口, means delicious and tasty. And it's very similar to the sound of the Coca here. And the last 2 characters, 可乐, is also sounds similar to cola in English. And it has it means cola. The Chinese mark, it delivers very good connotation, means tasty cola. is very good. And also there are a combination of both transliteration and translation like this one. The Chinese mark is composed of 3 characters, 星巴克, pronounced as 星巴克, where the first character, 星, is the translation of star, it means star. And the last 2 characters, 巴克, are actually the transliteration of the parts, box. So altogether is a combination of both transliteration and translation. And above the most frequently used methods to create Chinese mark, but you can always consult with us. We will be very happy to help you to create a Chinese name. And here some more very good examples for your reference. So this one is for BMW. The 2 characters means actually precious horse. I think it's very vivid and deliver very good meaning for the brand. So, before we start another part, I will say that it's very essential to keep in mind that the Chinese mark should be composed of characters with very good meanings. And we will stress conducting pre-filing availability searches for proposed candidates and selecting the marks clear of any potential conflicts with other prior rights before you file the mark and use the mark in the markets. Okay, now about the last question, what else should we need to learn about trademark protection in China? 3 very important aspects I would like to mention about is about a well-known trademark recognition protection in China, the customs recognition, and judicial and administrative routes against infringements. So a well-known trademark, there are many benefits for our trademark to be recognized as well-known trademark according to the trademark rule. Well-known trademark enjoys cross-class protection, and on the same goods or similar goods, the protection of well-known trademark can be even stronger than ordinary mark. But proof well-known trademark will require abundant evidence to prove the long-term use in the mark in the market and very high reputation. It's not an easy task, but considering the many benefits of well-known trademark recognition, so many of the clients are still trying very hard to get a well-known trademark recognition with the CNIPA as well the courts. And this is some of the well-known trademark we have successfully obtained recognition for our clients. And also in this case, we have a mobile to obtain well-known trademark in the civil litigation and get very good results. So for custom regulation, we want to mention this a very efficient and important, effective way to get border protection for your trademark rights as well as for copyright and patents. So, but they only allow for recognition of a registered trademark. So unregistered trademark is not allowed for recordal at the customs. Once we record a registered trademark at the customs, we can stop both imports as well as exports of infringing goods. So it's a very efficient and an effective way. So for in case we encounter infringement in the Chinese markets, what can we do? We can file civil litigation. So as well as it's very important to know that for civil litigation, we can stop infringement, we can claim damages. I don't want because time limits, I won't go deep, talk too much about civil litigation here, but I want to remind you that we have 2 routes of a fight against infringement in China, civil litigation as well as administrative action. Administrative rate action has the high efficiency. So we can carry out the rate action within a few days after filing the complaint with the local administration for market supervision. But for administrative rate action for this administrative routes against the infringement in counterfeit goods, we cannot get damages. So finally, before the end of my presentation, I would like to give you some strategies and tips. So file often and file fast. China is the first fight country. Again, legal problems can be prevented by filing a trademark as soon as possible and as extensive as possible. even before there's no, before you have any plan to foot on China. Choose your goods and services carefully. China adopts subclass system to determine similarity of goods, and we may leave no room for trademark quotas if we find mark in all the relevant clauses to obtain a broad scope protection. And create a Chinese character trademark. The label of imported goods require Chinese descriptions. It is also good for marketing. It's easier for Chinese people to recognize and remember a brand in Chinese characters. So think of the copyrights. Company logos can be better protected by registering copyrights in addition to trademarks. The protection copyrights is relevant to clauses. And register a trademark with customs. China Customs has the power to check what comes into the country and also what goes out. So finally, it's more costly and takes more turnaround time to involve international law firm. Choose a local partner who actually practice the law in the mainland China will be very helpful. So that's all my presentation. Thank you very much.
Perfect. Perfect. Thank you, Mrs. Zhao, for this mint presentation. I guess you covered a lot, and I learned also a lot from you. Right now, I'm doing a lot in China too, so it's every time it's new to me. And these examples for this distinctive trademarks with the Chinese characters, these examples are really good for us to understand how we can model a trademark by our own to file then in China. Now we cross the Pacific and we go to the US trademark, and here we have John Mutterly, which has been practicing patent practitioner, and it's an attorney at law specialized in intellectual property, licensed before the US, Swiss Patent and Trademark Offices, and also the European Union Intellectual Property Office and the Liechtenstein IP Authority. He is particularly specialized in preparing freedom to operate, infringement, non-infringement, invalidity, and unenforceability options on US patents, as well as preparing US and international patent and trademark applications. So he is a specialist in the US law overall and also in trademark law. So John, thank you for taking over.
Thank you, David. Let me see if I can get my slides up. Okay, just give me a second. Can everyone see that?
No, we didn't.
Okay. Just one moment. I think we'll have it up.
There we go.
Okay, very good. So first of all, thank you, David. Thank you to the Swiss Trademark Office, to the Serbian authorities for the opportunity. I'd like to disclaim the fact that what you see behind me does not indicate that I'm speaking for the Swiss government or the Torgau authorities. This happens to be simply our conference room, which happened to be the civil court of the area used for many years. So it has some trappings of a courtroom still. An 800-year-old building. You're all welcome to visit. Anyway, so we're talking about US trademarks. This is what we're going to go over, I believe, in the 40 minutes that we have. If we have more time at the end, we'll discuss some other details, but this is probably enough. Okay, what is a trademark? You know, it's really anything that can identify and distinguish goods and services. More specifically, it can be a word, and it typically is a word, or it has a word element, a name, as in the case of our firm, Da Vinci, a symbol, a device. It could be a three-dimensional feature like the Coca-Cola bottle. It could be colors. It can be smells, sounds. There's no limit. And so I challenge you to think of something more that might function as a trademark in the future. These that I've listed here are those that have proven and are registered as trademarks. Sounds, for example, I don't know if this will work. I don't have a touch screen, so you all know there you go. Okay, you know what that is. And that is trademark. What about, I'm just brainstorming here. What about a feeling? I don't know. You know, if you look at a product or you drink a product and you get a feeling, if somehow you were able to register that or capture that and quantify that, maybe you could even register a feeling. My point is, there isn't really a limit. The limit is quantifying and identifying it. So maybe some of you out there will be innovative enough to try something that no one else has tried before. There are different types. There are different types of marks. Ling mentioned certification marks. This is also possible in the United States. And it permits a person to register a symbol that they can license others to use that indicates something, a characteristic of the goods and services like quality or competence, for example, for a service mark. Another is a collective mark, which would be, for example, Gruyere cheese. These owners, that's also an indication of origin, another type of intellectual property. But the farmers that make a certain type of cheese can get together and register their mark as a collective mark. And it's used by all the members of the collective organization. Okay, there is also the possibility, as far as the type of marks, you can, as I mentioned, you can get a trademark for a word and also a logo, a device. Grayscale is the broadest type. It covers all colors. What's really unique about the United States, also Great Britain, Canada, Australia, these are common law countries, is your trademark rights are based in the use of your trademark. You have to use your trademark at some point. That's not necessarily the case in other countries like China, and maybe Ling can add more. There is a point of time where you have to prove use, but in the United States, just use alone creates common law rights. You don't even have to have a registration. That's not the case in China and other countries. So what are the benefits? Why should you register a trademark in the United States? One, the market is huge. One trademark application covers a market comparable to that of Europe. There is a presumption of ownership when it comes to enforcing your trademark. You really need a registration. There's a presumption of your exclusive right to use it as well. There's also the listing in the USPTO's databases, which the examiners have access to. That means when they're searching for prior rights, which is done in the United States, by the way, they will find your trademark registration and they can cite it against a later applicant's application. So this is important to know. In the United States, unlike in the European Union, unlike in Switzerland, unlike in China, you really have to, your application goes through an examination process and the prior rights are reviewed. So you will not get a registration unless the examiner believes that your rights are can be exclusive to your particular goods or services. You also have the ability, comparable to China, to record your registration with the US Customs and Border Protection Authority, and they will notify you if similar goods pass across the border. That usually involves some training on your part. If you really want to make sure that they catch everything, they have many applications. So it can be a time-consuming proposition, but there is the ability to register, and you should take advantage of that. Protection is granted for 10 years, as in most countries, and extensions are unlimited, provided you pay the fees. And you periodically can show that you're using the trademark in the United States. And why is that? I mean, some of you listening are used to patents, or you're thinking about patents, and you know that patents are only valid for, let's say, 20 years from the filing of a regular application. Why is it that trademarks can last forever? Well, trademarks are fundamentally different. Trademarks are there really to protect the public from confusion, to ensure that when a consumer buys a good or service, that they are getting what they expect. And so that's a service, in a sense, to the local consumer base in the United States. And there's no reason not to extend that protection infinitely, if possible. So what are the requirements for registration? Well, we talked about those. What's excluded? Anything that's immoral, deceptive, or scandalous. The name of a living person, a signature, etc. Now you think about our trademark, Da Vinci. It is a name of a person, but Da Vinci, God rest his soul, has been dead for 500 years. Another point on scandalous, this is something that the jurisprudence has been modifying over time. What is scandalous today is different than what was scandalous just 10, 15 years ago. The Supreme Court case in Brunetti found that the registration of FUCT as a mark for clothing was registerable, even though some would argue that it sounds like a gros mot in French that many would consider to be scandalous. Also the Redskins, that was another Supreme Court case where ultimately the Supreme Court decided that the use of the trademark Redskins by a US football team was not disparaging. Well, it may be disparaging, but it was protected First Amendment speech. Another that is excluded is a flag or coat of arms or insignia of the United States or any municipality or anything similar there too. Now here's another exclusion. You could perhaps use a portrait of Thomas Edison, because Edison has long been dead, or Da Vinci, which indeed we use. But if you use someone's image that is alive, you need their permission. Another exclusion is any mark that is confusingly similar to a registered US trademark. Now that's typical. In fact, most of the official responses we receive from the trademark office will cite some similar trademark. And if you file an international application, you'll get a provisional refusal that probably cites a similar trademark or has some other ground of rejection that you'll have to respond to. And when it comes to that, of course, you have to engage the services of a registered US attorney at law. Other exclusions, well, the use of famous marks under Article 6 of the Paris Convention is protected. It's called a right against dilution. And that's a good summary of exclusions. What are the registration requirements? And this is important to consider. You know, Ling talked about China. I'm talking about the United States. You in Serbia need to start in your home country. You need to file your first application in Serbia. You may meet all the requirements of Serbian trademark law and get a registration in Serbia. But what happens when you extend that to China and the United States? If you have problems there, then you could be blocked from getting trademark protection in a very significant country, which suggests that you should do one trademark search of some sort before you elect your mark. I would also recommend that you register the domain names that are important to you. That's easy and quick. And if you can't find the domain name, if you can't register the domain name, then maybe you need to find another trademark. So that's a good way, a place to start. That would be my advice for startups anyway. There are other requirements. You can't have a trademark that is geographically descriptive merely, or primarily geographically descriptive or misdescriptive or deceptive. And another that is an important point to make, particularly for the US, and the US because many other jurisdictions don't have this exception or an exclusion, and that is a surname. It is more difficult, and in fact, indeed, very difficult to get a trademark registration for a surname. And in fact, if you do try, it makes sense. I mean, it's your business. It might be your business name. And if you're the founder, you're going to be, you have a reason to name your business after yourself. The problem is that the examiner, if you do file such a trademark application, is going to look at phone books and see how many persons have this name. And if it's primarily merely a surname, you'll get a rejection that is very difficult to overcome. With time, though, registration on the supplemental register, it may be possible to get a surname registered. That's a detail that maybe we'll get into later if we have time. Also, if the trademark is as a whole functional, you cannot register it. That is part of the public domain. It belongs to everyone. So there are exclusions, but as I mentioned, the ability to, with time, become distinctive. That's called acquired distinctiveness. For example, a sound or a color or a smell. These things you can't just file and register. You have to wait. They have to cook on what is called the supplemental register. And after 5 years and of free use without being challenged, then you can get these things registered. Okay, the requirements for registration, as Ling mentioned, particularly for startups, and it's very important how the mark that you choose, because it has a lot to do with the ultimate costs. And so if you choose a mark that is arbitrary, doesn't really mean anything in relation to the goods or services you're offering, or fanciful, you know, like I would use an example, Apple. I mean, Apple is arbitrary as a mark for computers, or at least it was. Now you might think that Apple has become part of the English language to describe a computer or a mobile phone. But Apple as a word, an English word. It is a regular, it's a normal word out of the dictionary, but it has nothing to do with computer products. So it is a very good and a very strong trademark. So when you start out, you should be thinking about choosing a trademark that is going to minimize the problems you have in the different countries in which you're seeking registration. Because why? You're going to be paying attorneys to fight these cases for you, and you know how much we charge per hour, right? So you don't want to spend money needlessly. So take the time that you need to choose a trademark that is easy to register. Particularly as you seek money, your brand is going to be important. And as you spend money promoting your brand, your trademark becomes more and more valuable, at least as valuable as the money you spent to promote it. So another type of category of mark is a suggestive mark. This is something that merely suggests the qualities. I guess you could argue that Da Vinci might be a little suggestive because when you think about Da Vinci, Da Vinci was a genius, an inventor, an artist, a polyglot. So, you know, it's suggestive of the services that we offer, intellectual property services, services for innovative persons and companies. They're also strong marks. So, you know, you can't register descriptive marks. You can't register generic marks. These are things that belong to the public domain, at least in part with descriptive marks, but it is possible, there's a big difference. Generic marks, you can never register in the United States. Descriptive marks, after allowing them to cook on the supplemental register for 5 years, and if it hasn't been challenged, you can get a registration. They're weak marks though, and they allow for other competitive marks that are similar, closer to your mark. Again, probably not a good choice if you're starting out, you have a limited budget, you want to not spend more money than necessary on your brand. So don't choose a descriptive mark. Certainly don't choose a generic mark, okay? You might be able to register a domain name that's generic. You may be able to use it to bring people to your website, but don't use that generic mark as a trademark. You'll be wasting your time and money. Okay. Now, our firm, we file in many different jurisdictions. So, you know, we have the experience in filing in the EU and in Switzerland and in the United States and in Liechtenstein and through our partners like Ling in China. It's important to have that basic understanding to be able to choose the right mark that is registrable in these different jurisdictions. What's important, as I've been mentioning, is to think globally. Think about the overall picture. Think about where you ultimately want to go, where you want to protect your brand, which marks are critical for you, and then make sure that your first application in Serbia meets the criteria of the US. And why is that? Because under the Paris Convention or the statute in Serbia that has implemented that convention, you can claim priority only in the United States and other countries to exactly the same mark that you have filed in your home country. So you cannot, unfortunately, correct your trademark application. Yes, you can correct it, you can make it more precise, but you can't expand your trademark application And you can't modify your logo unless it's in the US a de minimis change, which is difficult to persuade the examiner of. So your first step is very important. And again, your first step should be in Serbia, because if you don't start in Serbia, you're going to have difficulty in using the international conventions, such as the Madrid Convention, to extend your rights in other countries. But just remember that the mistakes you make in Serbia are going to be made in the United States and in other countries because of this rule that you continue with essentially the same trademark in these other jurisdictions. You don't want to have to file a new application and start over again. Okay, another point is there's a classification system called the NIS classification, which are good. It's good to use. You can Google that. That'll give you some hints as to the wording for lists of goods and services. If you're going to be preparing your first draft application, I would recommend that you do bone up on the basics of trademark law, and you can help your attorney by already discussing your trademark, reserving the domain names for the trademark, deciding which brand you want to go forward with, doing some preliminary searching, again, because your own searching is probably less expensive than the searching by professionals. It'll be less thorough, but why not? If you find in your own search something that is too similar, then choose another brand. That way you can save quite a bit of money. Okay, you should keep your description short, clear, understandable. It makes it easier in responding to office actions, and it makes it easier to prove use. If you have a detailed list and you don't have an overarching concept of or product class, then it's going to be hard to prove use, because in the US now, particularly with audits of the list of goods and services, you're going to have to sometimes prove use of every single item that you list. So it's not necessarily the case that a long list of goods and services is a better list of goods and services. Okay, you can have a long list, but you should have some basic overarching concepts, like in our case, services, legal services. That covers intellectual property services, but then you could say semicolon, intellectual property services or monetization services and things like this. But legal services alone would probably be enough to start with. Okay. As I mentioned, you should search for prior rights. Again, you can do this yourself. You can also engage an authority like the Swiss Trademark Office and have them do some searching, or perhaps in Serbia they do some searching. There are plenty of third-party service providers that will do searching for you. We can manage searching as well. And the goal again is to find out the problems that you would have in similar, confusingly similar marks in advance, so that you can modify your first application to avoid these problems and therefore save yourself some money. There are a number of refusal grounds. Here, there's a comparison with Switzerland, which is not really relevant to you. But the examiner will do their prior right search, and as I mentioned, very often and most often will assert that there is a confusingly similar trademark already registered. That's not the time to give up. If you've done your search, you're pretty sure that your trademark is different than the mark that is found by the examiner, you've already considered this because you've done a search, I'm assuming, okay, then you can argue these cases. And that's where attorneys earn their bread and butter. We know the arguments that can help overcome these examiner rejections. And typically, for example, with an international application, you get this provisional refusal. You will almost always get provisional refusal. And very often it's very easy to overcome this. So don't give up at that point. If it's important to you, you've already invested money in the trademark, the brand, your investors really like it. Your pitch deck has flown around the world and been shared amongst the VCs with that name, then it's worth fighting for, okay? So, again, this slide deck is developed for Switzerland. If you are in Serbia, of course, your first application needs to be with your office of origin. And there is a period of time. This is very helpful for you in terms of costs. That is, there's this international convention called the Paris Convention that gives you 6 months to file outside of Serbia. So if you file and in Serbia and you have some trouble, and very likely you can request an accelerated examination in Serbia. If you have any trouble at all, then you can reconsider and file again if the trademark application has changed, and then still use that in a claim of priority in the United States and in China. So you do have the option of filing in the Madrid system. As I mentioned, it is a very useful system where you can just check off the countries in which you would like to extend your protection. But there are some problematic countries, and one is the United States. As I said, you're almost always going to get a provisional rejection. It's not the end of the world. It's just time to call a US attorney at law that has experience in trademarks. So international trademark filing, as I mentioned, you can file in the United States something that is identical to using the international system, the Madrid system. It's identical to your home country registration. And as I said, you can check off all the countries where you would like to extend protection to. There is a risk, and this should be mentioned as it is important. If you use the international system, Madrid system, there is a tying of your protection, your international protection, to your home country registration for a period of 5 years. So during this 5-year period, your home country registration, if it is successfully attacked, then all your international rights disappear. So it's important to get it right in your home country. But then think about the other countries in which you're going to want to extend your protection, okay? We, in order to avoid this problem, will file using the Madrid system, but almost always will file a separate US application so that it is disconnected from the home country registration, and it's not susceptible to this attack of the home country registration. If the European Union is also important to you, you might file a separate European Union application. Okay. As far as our firm is concerned, I mentioned the offices where we can file, and through our network of associates, including CCPIT, by the way, I would like to say is certainly one of the best, if not the best firm in China, and particularly the best firm to use if you have any border issues in terms of trying to register your rights with the border authorities in China and enforce your rights and prevent them infringing goods from passing through the border. I think we have, let's see, we've already discussed this, and we can move on to the next slide. We have time. How many minutes do we have?
32 currently.
We still got like 10 minutes if you want.
Okay, so let's start the next one. Is it up? Okay. Should be up in just a second.
There we go, John.
Okay. Now the US has multiple options in terms of a filing basis. It can sound rather complicated, but to try to decipher these, I'll go through them. A 1A is use in commerce. That's what triggers your ability to get a registration with the US Trademark Office. You have to use goods across state borders or between a foreign country and the US borders. Okay, that's use in commerce. Ultimately, you're going to have to use your mark in commerce. So even though at first you may not be using it in commerce, ultimately you will have to. But because you may not be using it in commerce in the United States, particularly if you're a startup and you're starting, let's say, at Serbia and expanding your services or your goods across Europe, you can file in the US based on your bona fide intent to use. And that can be amended at a later date. There's also, based on your Serbian trademark application, foreign priority, that's under the Paris Convention. And also 44E, based on your foreign registration. It might be, you'd have to talk to a Serbian trademark attorney, but you should be able to pay an additional fee and get a registration in Serbia within the 6 months. And then once you do that, you can file that application under this basis 44E in the United States, based on your foreign registration. And you can essentially get that trademark registered in the United States as it was registered in Serbia. Of course, it's susceptible to attack at a later date if it's not used or if there is a likelihood of confusion with an existing mark, et cetera. There's also the basis of 66A, which is the extension of protection based on the Madrid Protocol. That is the basis when you go through the Madrid Protocol and when you get a provisional refusal, it's based on 66A. You can choose multiple bases. So you might start with 1B and then also have a foreign priority. So you also choose 44D. You also might have a foreign registration. So you have 44E, et cetera. So again, this is where it gets a little bit complicated, and it's good to have the advice of counsel when you're dealing with the United States. This is, these are the bases in a little more detail. Okay, if you file under 1A, which is use in commerce, you'll have to provide a specimen that proves your use. And the USPTO is very picky about this now. They were much less picky about it in the past. They will look at your specimen and critique it if it looks like you have just created it, paint shopped it, or just cut and paste it from your logo graphic. They're going to reject it. They want something that looks like a real specimen, a label. If it is a good or product that you're selling, that would be on the goods. Okay. If you're filing based on intent to use, after registration, you get a notice of allowance. You don't get a registration. And then you'll be given 6-month deadlines during which you can provide the specimen to prove use. Okay. The interesting thing about this 44E, based on the foreign registration, you will get a trademark registration in the US based on your foreign registration without the need to prove use. And that's useful for startups because you'll have then a number of years before you have to actually prove use. Okay. And then there's the 66A basis through the Madrid Protocol, which also allows registration, initial registration without having to prove use. Okay, so there are deadlines, and this is where attorneys outside the United States often misstep. They will file using the Madrid system, and then they will forget about the deadlines to docket, which is the non-use or the use deadline, and also the 6-year deadline for a declaration of use. These are things that the US Trademark Office don't remind you of. So, in fact, we pick up many a case from Europe-based attorneys that file using the Madrid system or file based on a foreign registration because they don't docket these deadlines. And they will get a notice of abandonment of their rights, which is rather embarrassing to explain to your client. Okay, so this is important. You need to make sure that somebody who knows the deadlines gets a hold of the file, the US trademark file, as soon as possible. Okay. As I mentioned, there's this 5-year dependency. That's why we file separate applications. As I see here, I think we're getting into more detail, which probably won't interest most of the audience, and perhaps we can save the extra minute for questions and answers, if that's okay with you, David.
Yeah, thank you, John, for sharing with us your experience here, also with the deadlines. So if you file an international application, you're not off the hook. So in US, you have to watch these deadlines. So we have one question which was written here in the chat, which is asked for China and US, and somebody want to register the word Athena, like the Greek capital, as trademark. And the question was, it is theoretically possible, yes or no? Of course, we are lawyers. We have to ask for which goods and so on. And I also made a research about Athena, and in China I have like 381 trademarks which has this word in it. In the US is like the double. So Athena is like quite common for trademarks, I guess. So perhaps I just answered one question. It is actually in somehow, but the second question is, when you made a trademark like this, how to proceed? If you do I go to my Serbian attorney when to file a trademark like this in China or US, or what do you think? Yeah.
If I may, David, if I were asked this question of a client, I would say the good thing about this is the fact that it is widely used, and that means it's less likely that you will be challenged. But at the same time, it could be that someone has a trademark with Athena for the same goods or services. That's a problem. That's a problem. So you need to look at all those registrations, those 300 registrations in China, if China is a very important market for you, and the 600 in the United States. And there's a way you can do the search based on classes, and then you limit that list to the number of trademarks in your class. And then you have to look at that and see if you think that is going to be a problem. If it's the same class, it's more likely to be a problem, but there could be, because there's so many players using Athena, that you may be able to get around a problem of likelihood of confusion with a logo. So that would be my initial input.
Yes, I agree that it seems the problem here is not about the trademark per se, it's about the likely conflict with prior rights. So I think that Athena is very popular even in China. We all like Athena a lot. So there's lots of prior rights already. So we need to conduct pre-filing searches to eliminate, to see if there's any possible conflict you want to register before in China. Yeah.
I guess the question was also about, Athena is the capital, it's a city, right? So we have kind of geographical indication somehow, perhaps, the question. And you both mentioned that, the misleading of the indication could be a rejection, could be rejected by the offices like the USTPO and the SNIPA or the CNIPA now. What's your take on this?
Okay, it's not the same as the city name thing. There is a two letters difference. So they still primary the name of the goddess, the Greek goddess, and I think it's not very risky regarding the religion meaning, because it's more like fairy tales to Chinese people. So I think it's okay. The most serious problem is the prior rights, the prior registered trademarks.
Okay, so I guess we covered that question. If no, come back and ask more questions about this. We have a second question here, or two questions in a row. The first one, do we have to engage a lawyer in the US if we want to register a trademark in the US? It is mandatory, or what's your take here, John? Yeah. You will say yes, of course, because
no, I'm not going to say yes. Our goal as attorneys is to help ensure the success of our clients, and part of that is to ensure that their money is spent wisely. Let me repeat or emphasize the things that I've already said. Choose your trademark wisely. That helps you save a lot of money. But when it comes to requiring a US attorney at law. If you're an individual, you do not need to have a US attorney at law. Unless the application is based on I'm sorry, but if you're an individual, you do not need an attorney at law. That's called pro se. And so you can represent yourself pro se. If you're a company, you do. So any company applicant is going to have to hire a US attorney at law. I do have someone here that would like to add a point on that. She is also a US trademark expert. Would you like to make a comment?
In a foreign country, there's this new request for a US attorney.
Yeah, but yeah, she's just mentioning there's a new rule, and it is rather new. I'll have to look at it again, but I'm going to go with, if you're an individual, you can represent yourself. If the US Trademark Office has just tightened that up and doesn't allow you to do that anymore, then great for us, but bad for you.
Okay. I know that also in China, you at least need an address. Also in Switzerland or in Serbia, it's the same. You need an address where the trademark office can send you the letters, and perhaps you need also a responsible person for you there. So Mrs. Zhao, how it is exactly in China? Do I need really a lawyer for my trademark application, even when it's in an international one in China?
For international registration, we don't need to appoint a lawyer when filing. But in case you encounter office action, official refusal, you have to appoint a trademark agent or lawyer to help you to find a response or a file review with the review board. For filing national applications, you need to appoint Chinese trademark agents. Yes.
Right. Thank you. So the core is actually, if it is safe to have someone there in any time. So let's talk about the money, because, I guess a lot of startups, they want to file their trademarks, firstly, perhaps in Serbia, then they ask themselves, okay, China will be a market. I'm doing things online, so, I perhaps need a better protection worldwide, perhaps in China and the US. We take this too. What can I expect? What cost comes here? I say for 3 classes, for example.
Okay, for filing one mark in one class, the costs are estimated to be about 370 euros, about $390 US. That's for one mark in one class. And then for 3 classes, it's around 1,000 euros. Yeah.
John, what's about the US? They're much cheaper, right?
No,
I'm joking.
Well, the US, the filing fee is around $300 and some per class. I think there's a difference in China. China, you have to have separate applications. So you're going to be filing, now, Ling, you correct me if I'm wrong. For each class, you have to have a separate application. In the United States, you can put them all together, okay? But for each class, you're going to be spending about $350 in official fees and probably $300, the same again in legal fees. So if you have a multi-class application that has 10 classes, then you can expect around 3,000 in official fees and 2,000 or 3,000 in attorney's fees.
Let's talk about attorney's fees right now, because this is also a question. Of course, it's all about the money, but we take this example. I have the trademark. I will file it in Serbia, and then through WIPO Madrid system, I will file it in China and US. And perhaps I will file again in US separately, as you told us, John. Let's make us a budget. What's the budget for 3 classes? What is it overall? What costs I have to expect?
Well, that's a big question, because you're saying filing in the Madrid system.
Let's say the filing through Madrid system. I have my trademark attorney here in Serbia, and he will do the national Serbian and the Madrid, right? But you know, I need support for a US attorney or a Chinese attorney. What are we talking about the costs here?
Well, you know, as far as a US application, what I wouldn't do, by the way, and I think you had to, maybe you missed, there was a typo in your speech, is if you file a Madrid application using a Serbian attorney, I wouldn't designate the United States in that Madrid application and file a separate US application.
Oh, okay.
I would save the money because the filing fees are going to be about the same. I would not designate the US in your international application, because in the case of 3 classes, that's about $1,000 in official fees that he will be paying. That can go to paying the official fees for a separate US application. And in most cases, you would pay another $1,000 for attorneys' services.
Okay. So I misunderstood that. Sorry.
Well, you know, don't double pay. You know, you pay one official fee per class. So if you do a separate one, pay that fee in the separate application. Don't file it, don't pay it in the international application. And also, the use of an attorney depends on whether or not there's a refusal in the United States, for example, in this case. And so typically, as I said, there will be a refusal. And for us to intervene in a typical case where there's a refusal will cost maybe 1,500 Swiss francs or US dollars.
Okay, Mrs. Zhao.
Yeah. So the estimated 370 euros is cover all the costs of filing one mark in one class national application. So 1,000 is also the total cost for filing one mark in 3 classes. We can also file multi-class applications, but we don't recommend that because the costs actually are the same. And it's not very convenient in case we want to divide the classes. So we would suggest that we're filing application for one mark in one class for each, and the cost is actually the same. So for 370 euros, the total cost include the official fee, which is actually very low, as 300 RMB for one mark in one class. If the number of goods is within 10, there will be extra official fee for each additional item of goods when the number is over 10 in one application. But the official fee is not, it's cheap. So 370 for total for one mark in one class, and 1,000 for 3 classes. That's the cost. So for in case the mark goes smoothly and then there was no further cost, there's no publication fee. There's only about $50 US for registration certificate fee. That's all. So.
Okay, and if I need you for, you know, if I have a refusal, for example, I need a Chinese lawyer. Of course, it always depends how much work you have to put in. But for a simple refusal, like to get, for example, an authorization by a company or by a country to get that?
Generally, generally the cost for filing a review of reviews for one mark in one class is about $1,000 US. Generally, yes, average fee.
Okay.
Including the official fee and our attorney fee. Yes.
Okay. Okay. So we have here a number. Let's talk about colors. This is, or it could be something special. Should I file my trademark in color and in black and white? What's the take on the color? In China, I know there is something different.
Yes. If you will register mark in black and white, we can use the mark in any colors you want. So black and white is sufficient to offer protection for your color mark. But in case the color is a very, very important element of your brand, I would suggest that you register the mark as how it's used in the markets. So.
Is it the same in the US, John?
Yes, essentially a grayscale covers any color. And so if you're a startup trying to save money, I would just file a grayscale application of your logo. Obviously, if you were seeking protection for a word mark, which is the broadest protection, you're not going to have a logo. You're not going to be dealing with color. But I would consider filing at least in grayscale, and you know, the color. If you have the budget, then go ahead and file it.
Okay. There is one more question about the system overall. Does the U.S. Federal Trademark Registration covers the whole U.S.? And the same goes for Chinese. For China, does the registration by the Chinese Trademark Office covers the whole country? I guess yes, right?
Yes. Yes.
John, I heard of that we have also different trademark offices in the US, not only one. Is that right?
Well, there's been an effort to kind of spread out the offices across the United States, and it started with patent offices. So there's one in Denver, there's one in Dallas, and so on. That's because of virtual work of the examiners, and also to facilitate interviews with the examiners, particularly in the patent cases. So yes.
It covers the whole US. Okay.
Yes, by the way, it covers the US. The trademark covers the entire United States, including its territories. So Puerto Rico and other islands would be included.
Okay. There is an interesting question here. Is it possible to register smell trademarks? I do know one in the US. That's the toy. What is it? I guess we have one in the US. And China, I'm not sure if we have a smell trademark. Tell me more, John, perhaps for your side in the US.
Mm-hmm. Well, as I mentioned, essentially anything that's capable of identifying your goods and services, and that you can somehow capture, you can try to register in the US. And in the case of a smell, there would be swaths of the product that has the smell that you have to submit with the application. But this is something also that is expensive, because you have to often provide evidence of this acquired distinctiveness. You would not be able to register it right away. You could file and then put it on the supplemental register, which is just a register that allows your rights to be published and available for searching by examiners and anyone else. It gives people notice of your claim to the rights and gives them an opportunity to challenge your rights or to warn you not to use these rights. If you survive the gauntlet of 5 years of being in the database without challenge, then you can register these, as long as you can quantify it, you can identify it sufficiently.
How it is in China? It is possible to register a smell trademark.
Well, we don't have any smell trademark in China yet, but anyway, the trademark law is kind of open, so we didn't. It's likely it's possible in the future. Can try the smell mark, but not yet any smell mark as so far as I know in China.
Let's talk about this creation we have in at UIPO just I guess 2 years ago. They opened also the possibility to file MP4 trademarks or MP, sounding trademarks. How it is also possible in China and US to register MP4 or a sound trademark. In the US, we have, my question.
Yes, in China, we have a sound mark. Yes, the sound mark John just mentioned at the beginning of his presentation. The roaring lion of MGM is also a register. I think it's registered in China or not. Maybe yes, we have our sound marks in China now. Yeah.
I'm not sure if you can register MP4s as a format, but I would imagine now you can. WAV files were the way to do it. But a sound trademark is very rare. And I don't know, there are probably, my guess is maybe 50 sound trademarks registered in the United States. So our firm hasn't had the ability to handle a sound trademark as of yet. And very few US firms have had that opportunity.
Good. I'm looking through the chat protocol. I don't see any more questions. I have one more question. Now after all, and we went through the international filing and the national filing, and for the national filing, it is perhaps a bit different here in China because you have subclasses. We don't have, I guess, in the NIS system. What's your take on that? Because when I do file internationally, I do not have the subclasses, right?
No. So when the international registration extend to China, the CNIPA they will put your goods into different classes according to description. Yes, we need to give the subclass number to each item of the goods, so that when you put into input to the system of the CNIPA, they can compare similarity of the goods with other marks, do the search in the examination procedure. Yes.
Thank you. So we don't have here any more question in the chat. So all the participants is on you to ask now questions. We have here two specialized trademark attorneys for the US and the Chinese system. Please go ahead to ask questions. And there we have, no, nothing new here.
Oh, may I make a suggestion, David?
Yeah,
we do have a Serbian translator with us. So if someone would like to ask the question in Serbian, we can have it translated. So don't be shy.
So if not, I have just, the takeaway from today is, I guess, first, we do need really a distinctive trademark. That's really the core of it. You need a trademark which is, it's not Athene, I guess. Secondly, I have to make my research, and my research not only in Serbia, I have to make it in China if I want to enter the Chinese market, which we all know it's really important globally, and the US market as well. So I need to make some research by my own to use these search engines provided by the US TPO, for example, or the Chinese trademark office has also one. It's all in English. It's really not so sophisticated, and it is also simple to find, even though it is also good to have something on the back, an attorney or a third party who will do your research on that. Thirdly, think twice when and where to register your trademark, and be really careful in which classes you do it, in which colors, how it is, and be careful about the similarities and not similarities in the US and China. You can do it internationally without a problem. There perhaps one in the US, because they will give a refusal. At this time, you need somebody in the US, or a US attorney at least, to help you out of this. If you have a refusal in China, it's the same. You need actually an agent or somebody in China to help you out. It is quite common, these refusals. It depends a bit about your trademark, and it depends how good your work was before, right? Your preparation on this. Mrs. Zhao and John, do you have any adds on my final, my final takeaway here?
Yes, David, I'd like to confirm that the USPTO recently announced the requirement of a US registered attorney for all foreign applicants. So that's bad news in terms of saving money, but good news in the sense that you'll be required to get counsel earlier, which can save you money in the future. The other point I wanted to make is that when you do searching in the United States, you have to keep in mind that there is not just the US Patent and Trademark Office database. If you want to be thorough in your searching, many states, not all, but many states, for example, Texas, has their own trademark registry. So these are registered rights that protect the rights similar to a US federal trademark right, but in the state, okay? And so if you want to make sure that you are free to use the mark in critical states in the United States, like California and Texas and Illinois, New York, you may have to do a local trademark search. And also keep this in mind, that even without a registration, there may be rights, because the United States is a common law country. So not only should you consider checking the trademark registries, the US Federal Trademark Registry and key state registries, but do a Google search or a Bing search if you prefer for that trademark, and see if you can find a product that has a name, Athena in the case of the services that coming from the chat box, already in use. So, the fact that someone is using it is enough to protect it in the United States. You're not out of the woods if your trademark search shows that there are no other prior rights, okay?
Thank you, John.
Okay, I think the most important thing for filing trademark is to remember the first to file rule in China. We don't require use of the mark in the markets. We just file it when we before we planned any business, have any actual business plan in China. So register first and get protection. That's important.
Thank you. We have one last minute question here. How often it is recommended to file domain? I don't know. Specimen could be, but this is in US. With trademarks, in which situation? What about court protection, if possible to answer? Domain. Oh, okay. To file a domain with it. John actually mentioned that you perhaps go for the domain first. If the domain is already taken, you should be sure that there is a trademark or a use of this name in the market somehow. So perhaps there is the beginning of your search by registering a domain, and you go through, like, you know, .com and so on and so on. But it's not necessarily to have a domain name and then file a trademark or whatever. They have a connection somehow, but if you are a trademark owner and there is a domain name holder which comes after you, you have a prior right and you have a trademark, which is mostly stronger than a registration of a domain. Am I right? I'm sorry to interrupt. Mrs. Zhao, what's your take on domain names, trademark, which should be first, how we can deal with that in China?
I think trademark is because domain, we have the domain name resolution, dispute resolution system. We can file a domain name dispute resolution with the arbitration, but the domain name disputes based upon the prior trademark rights. So I think it's important to get the trademark rights. And for domain name, we can file the resolution and then file the dispute resolution and get it back. So, yes.
Yeah, David. You know, I say try to get that domain name first. Keep in mind that, let's say, in the case that I've been using throughout the presentation, DaVinci, if DaVinci.com is registered, well, maybe it's for surgical robots or something like that. It's not related to what you want to do, but what we want to do, legal services. So that shouldn't prevent us from going forward with a DaVinci application, because we can get a trademark on DaVinci Partners, for example, or DaVinciLaw.com. I mean, I'm sorry, we get a domain name registered for DaVinci Partners or DaVinci Law, and then we use that as our website address and go forward with a trademark application. If you go forward with the trademark application first, and then someone else comes in afterwards and registers a domain name, then there is an attack, possibly UDRP, and where you can register, well, you can attack that trademark, that domain name, and get it back. But it's a rather expensive process. It takes a few months. You want to avoid that.
Okay, John. We mentioned earlier that when we have a registered trademark in the US, the whole US, the United States, and all the it's covered by trademark protection. And then you mentioned, okay, they have also trademark registers in the States separately. Mm-hmm. Should I register my trademark if I know my market is only in Texas? Let's say that. Mm-hmm. Should I register my trademark only in Texas and not in the whole US?
Well, if your market is in Texas, I would check the trademark registry in Texas. But if your mark is free in Texas and not registered in Texas, and you are reasonably sure that no one is using it in Texas, then file the federal application, because if you get it, you're going to cover the rest of the world. Even if someone is using it in Texas, if they're only using it in Texas, you'll have the rest of the United States protected.
Yes, but can I protect protect my trademark only in Texas?
Yes, you can.
Oh yeah, okay. And so I can also pick, you know, state from state, but it is common now, I guess not. You just protect the whole US, because it's the costs are, I guess it's much lower, the cost to protect the whole US than separate states.
Oh, yes.
Yeah.
It would clearly be lower. But, you know, people who use the Texas Trademark Registry are those that only intend to practice locally. They could be professional engineers that are only registered in Texas. They could be attorneys that are only registered in Texas. They could be landscaping companies that just limit themselves to a city or geographic area within Texas. So it's not that serious at the Texas Trademark. If you do register a Texas Trademark and nothing else, you're saying, hey, we're just local.
Okay. Okay. With that being said, thank you, John and Mrs. Zhao, for your help here to get across all these hurdles and on the US and Chinese system, and for your time. I guess in China it is really late. And thank you for your time and your effort here to bring us a bit closer to the Chinese and US system. And yes, and for all you participants, it was nice for me to get you here on board. And thank you, Ivana and Giovanna, for helping us out to manage this event. And yes, that's...
Yeah, thank you. Thank you, everyone, on behalf of Science Technology Park Belgrade, and info for our participants that the video of the webinar will be available on STP YouTube channel. So if you want to listen it again or to share with your friends or colleagues, you can do that.
Thank you. The pleasure was all ours.
Thank you.
Thank you, everyone.
Bye, everyone.
Bye.
Bye.